Tim Blankenship here with divorce661.com, and today we're talking with Kimberly Keen, who is a family law attorney in San Diego. Hey, Kim, how are you doing today?
I'm great. How are you, Tim?
I'm doing well. Glad you're doing well. Glad we got together today. I know your practice and working as a family law attorney keeps you busy. This was like our second reschedule, I think.
Yes.
You had a busy caseload, I think, and court kept you over. And then I think last week I had an allergy attack.
That's
So,
right.
just to introduce you quickly, and then I'll let you kind of take over. Kim is a San Diego native, and you please correct me if I get something wrong. Currently a family law attorney, practicing family law, obviously in the San Diego area, and covers all courts in San Diego County. And I believe you are mostly kind of in the North County area, but you also handle cases down Central and South, I imagine.
Yep, all over.
Okay. Just kind of looking at your website, and it seems like you have a kind of a goal of focusing on women's issues, domestic violence restraining orders, but I gather you will take all comers. Do you want to just kind of give us a brief overview of what you got going on and a little bit about yourself, and then we'll kind of go from there?
Yeah, sure. So I definitely don't just focus on women's issues. That's something that is a kind of a passion project of mine. So I like to volunteer at different domestic violence clinics and things like that. But I find that in my practice where I do get paid, I tend to actually prefer to focus on more complex financial aspects of divorce. So I like to focus on, by the way, just divorce. In family law, I do here and there, like paternity actions and just child custody actions, child support, things like that. But I do prefer to just focus on divorce, and particularly high asset and also high conflict divorces, because I just find that to be the most satisfying. It's funny because, they always say if you're a lawyer, you're not good at math. And I didn't ever think that math was a subject that I enjoyed growing up. But I think as I've become an attorney and everything is so word-based and it can become very convoluted and you kind of get lost in what you're really requesting. I find that when I'm just focusing on the numbers and formulas and what have you paid or what do you owe or what's owed you, I actually find that a lot more that focus to be more rewarding. I think especially because in family law, things can get very kind of lost in translation, especially with clients, because there's a lot of emotions obviously involved. And I think that getting back to the numbers, back to the formulas, back to the law kind of grounds everybody involved. And then I tend to feel too in that way that there's more of a fair shake at the end of it than just kind of listening to testimony and, okay, this person's more credible than that person. Well, the numbers, they can lie technically. You can fudge your numbers, but it's harder to do that than it is, I think, to go on the stand and try to convince the judge of, a situation that may or may not always be true using emotions. So I like to focus on more of the technical aspect of divorce.
So just you try and focus on the facts and less on the emotion is what you're saying for the most part?
Yeah, I think, it's hard to completely, pull them apart, obviously. But I think the more I focus on that, the more satisfying, honestly, my practice is for me. And I think the more rewarding it is for the client, because it's not just he said, she said anymore, which is a big complaint too in family law, especially dealing with lawyers, is they kind of prey on that I don't want to say prey, but play on that kind of emotional aspect in order to get your case forward. And I'm sure you've noticed this too. I mean, you're not in like the litigation side of it, but
right.
In a lot of pleadings and things, like you'll see an attack on like even the other attorney, or, the meet and confer efforts. And it becomes very petty. And ultimately that's not what the judge wants to see. That's not what the law is based on. And so I try to avoid that as much as possible.
Yeah, that's interesting. So what you do is, even though I didn't want to say there's some crossover, because it's interesting that you want to handle high conflict. And if I hear 1 inch of a disagreement at all, I don't want to work with them. Just, I don't have the tolerance for it. It frustrates me to have people bicker and just, not, and just focus, like you're saying, they focus on the emotional versus just, if they would just put the emotion aside and get into doing, first of all, what's best for the kids, right? And then figuring out the assets and go from there. Do you see this? It sounds like you see this both in like pleadings with the court, but also in what maybe the attorneys are writing in motions and so forth, and kind of putting down, like you said, the attorneys and putting all that mess into it versus just focusing on the facts. Does that, what I'm interested, like when these go to court and the judge is reading these, are they not realizing that that's not having a benefit to them when they're doing those types of things?
I mean, I think it has a time and place. If you're asking for sanctions, for example, for litigious conduct, that obviously has a place there. Or if somebody failed to meet and confer, it has the place there. But yeah, I mean, I think for the most part, it is something that a lot of attorneys just kind of like to do. They like to fight and they like to poke holes on the other side. So whether it's relevant or not, it does like inevitably come up. And I do point more to the attorneys on this than clients, because this is really an attorney thing. Obviously, clients, if they're representing themselves pro per, I don't blame them, because they don't know, it's like they're not an attorney. They're not quite sure what to put in pleadings or how to frame their arguments in a way that, is the best way possible. So I really point my finger there at the attorneys, but I don't know if it really does much damage. I have seen a few cases, usually the judge kind of just ignores it, but I have seen a few cases where the attorneys are pointing things out about the other side, or they're refusing service and they're doing this, and the judge will just come in and say, you need to figure it out. And they'll say that the same thing to the parties too, right? If they're, especially with child custody disputes, if they're both, back and forth, like he won't drop him off on time, and here's 10 instances of that. The judge doesn't want to make orders about that unless it's something that's, pretty egregious or putting the child in harm's way. So they'll just, kick it back to them and say, you need to learn to co-parent better. It's essentially what they do with the attorneys too. You need to learn to lawyer better, or to develop a relationship with opposing counsel that is beneficial, because I don't want to deal with it.
That you're talking about the judge.
Yeah.
Do you find that being more of kind of working collaboratively to the degree you can when representing your clients versus it going to trial, do you find that there are attorneys that are more just, they want to take it to court, they don't want to negotiate a deal, they'd rather just go and see what the judge orders and thinking they'll get their client the best deal? Or is it kind of 50-50? How does that pan out?
I definitely think there are certain firms and attorneys who prefer to litigate. But I don't necessarily think that's a horrible thing. I think as long as you're making a good faith effort to meet and confer and do everything that's required of you to settle, and you're not pushing your client to, go to court, even if it's not in their best interest, I think that it's still it's a balancing act, right? Because I really do enjoy being able to negotiate a good settlement for my client. That's really satisfying. And I think it's just as satisfying as going to court and winning on a motion or winning at a trial, especially because a lot of, in both instances, there's a push and pull. You're never going to get exactly what you want for your client. That's just how it is. So I think there's satisfaction in both. There's some attorneys who do prefer to litigate over settling, but like I said, I don't really knock them for that, because in some ways settling can be more detrimental to the client than going to court. There are instances where the other side offers them something, an offer. Oh, I don't know if we froze or if you froze. Uh-oh.
That's okay. I think we're back.
Okay. I don't know where we left off, but
I guess I'll be doing some editing. No, you were talking about it sometimes it can be to the detriment by not litigating.
Yes. And I think that on one end, you have to be, you have to make sure that settlement is number one because you're in family law, but you also have to be, you have to represent your client's best interests. And it's always it's always a give and take with that. But yeah, and honestly, sometimes it's almost easier to work with those attorneys because what they're going to do. It's
Right.
more predictable. That they're probably going to end up at court. They're probably not going to agree to your settlement offer. And honestly, I think that it does make me a better attorney because then I can see, oh, they're saying, even if it's just a threat, like there's a sanctions of a certain amount. Oh, I didn't really know that you could do that for this, even if they don't pursue it, and then it forces you to keep you on your toes. It forces you to respond also aggressively in a way that is maybe more creative than them. If they're coming at you aggressively, all of a sudden you find yourself on the defense. You don't really want that. You want to make sure that you're always on the offense. So if they already have caught you a little bit behind, it forces you to get more creative, forces you to kind of advocate even stronger for your client. So I don't always think that it's a bad thing that attorneys are like that.
Yeah, when you were talking about, meet and confer and trying to settle, I remember, so going back, I was just looking at the notes that I had taken. You had started, well, not started, one of your experiences was as a volunteer law clerk for San Diego Superior Court, in the family court law facilitator's office. And so in doing so, you saw kind of the behind the scenes. You got to see kind of the court. Now, was that in the family law facilitator? Is that like the self-help center, or was that what am I getting that right?
Yeah, it's essentially what it is. It's kind of a self-help versus you can also talk to attorneys, but since they're working for the court, they can't give pro pers legal advice or anything like that. But yeah, it was a really great place to start family law for sure.
For sure. I was just because my background is kind of similar in I was working at the court as well as a volunteer judicial assistant. So in the courtroom, so got to see all the play on how that, and I would be in judges' chambers, and you got to know all the behind the scenes of that. So when you were talking about the whole meet and confer and all that, I remembered because we don't do anything with court actions. I remembered that there was a ramp up. It wasn't just you file for divorce, you're not in agreement, you go to trial. There's a lot that goes in between, and attempted mediation and direction from the court before. I mean, are they still treating the trials as a last resort? Like they try and get you guys to do everything before it'll actually end up in front of the judge?
Yeah, I mean, trial is kind of a last resort. You always hear that, right? I mean, even when I'm in court, the judge will always make sure that we're meeting and conferring. If they see that there's 4 or 5 RFOs on calendar, they're going to bring it up, and they're going to make probably a separate order for you to try to at least consolidate the hearings and things like that. So it's always that balancing act, because especially as an attorney, because you want to make sure, for me, I don't want my client to agree to a settlement if I know that they could probably win at trial, and that's a decision that you make with your client. But you also don't want to piss off the judge, and that happens quite a lot if you're filing a lot of motions, or especially like DVROs that maybe you shouldn't file, or maybe, you can easily settle with the other side. So it's definitely a balancing act, but yes, the law encourages it, judges encourage it. And I think at the facilitator's office, it's a little different because they're not really encouraging anything. It's just, hey, I want to file this, and then here's how you do it, the forms.
Right. Do you have to have the conversation with your clients when negotiating settlements to say, hey, I think if we went to trial, this, and I'm coming at this from more of the kind of the financial front and attorney's fees, like, hey, I could probably get you a better deal if we go to trial, but this could be another 50 hours or something like that. Is there a point when sometimes you may just it's kind of what's it called, good money after bad, or bad money after good, as far as I can get this, but at the end of the day you're going to be net negative?
Yeah, I mean, that comes up all the time, every day. you're always weighing the benefits of okay, look, even honestly, any motion and any, it obviously particularly comes up when the client starts, they've been represented for a long time. Maybe it's a really litigious case, and then they'll say, hey, how much more do we have to go?
Yeah.
And sometimes it's years. And then at that point they have to assess whether they want to continue keeping you on, whether they want to do some things themselves, things like that. But it's definitely a conversation that comes up, I would say, honestly, almost every day with clients about, and I think that's normal. And, I'll even bring it up if they don't ask, because I think that's fair, especially if, let's say they're trying to pursue modifying, some support order that ends soon or something like that. And then I'll run the numbers quickly and say, look, we can do this, but you're going to be out more than if we actually won this motion. Yeah. So that's definitely a consideration all the time. You're bringing that up. I mean, it's pretty much, it's divorce. You're always going to have these conversations about money and attorney's fees.
I thought it was funny / not funny. So I also worked for a family law attorney about 11 years ago as a paralegal for maybe a year before starting this business. And we'd always know when the billing went out. So I don't know if this is how the retainers are still today, but they would have they'd have a retainer that they'd pay, but in the retainer agreement, it said, this is obviously just the getting started money. Once we go over those hours, we don't have to really notify you. We're just going to continue billing, and you'll get a statement every month. And we would know, because I think we had maybe 7 paralegal staff. So it was a pretty big firm. And we would know when billing went out, because the phones would light up of people wanting to settle because they just got their bill.
Yeah. Same thing here. I mean, the day we send out invoices, it's pretty much guaranteed that you're going to get a call or two, but I think I found that the best way to mitigate that is, I mean, it's a balance too, because you don't want to underbill, because you are performing a service, you are doing the work, you don't want to cut yourself short. I think that's not fair to you, but that's also not even fair to the client, because it's like, why would you want to see on your bill that your attorney's spending 10 minutes, like 10 minutes on preparing for your hearing? They should probably be preparing more than that. But yeah, I mean, I think the best way I found to mitigate that surprise is by telling them up front, this is generally the monthly retainer that you're going to see. And then it kind of sets their expectation of, okay, it could be less some months, could be more some months. But if you give them a ballpark of, within $500 to $1,000 each month that they're expecting to see on their bill, they definitely are, they will contest it less and they'll question it less. And I think that's something that attorneys need to work on in general. Obviously, with a flat fee practice like yours, it's a lot easier. People know what to expect, but it's a balance too, because not everything can be flat fee. A lot of things, you do have to do on an hourly basis. But I do think as attorneys, we can definitely do better in notifying our clients and bringing them up to speed on what their bill is going to be. Because I can't imagine they're spending so much money a month, and I can't imagine being surprised at a bill every month, and maybe my credit card is going to go into collection because I'm just trying to get this service for myself. So yeah, I think being more transparent about billing up front ahead of time, because once the client starts disputing the bill and you're going back and backtracking and justifying everything that you've inputted, it's already a dispute, and they're not going to want to work with you after that, they think that your bill is not justified. So I think to answer your question, I think being more upfront about the general range of what they can expect each month, I've found does help with that uncertainty.
And I'm sure that varies, right? Because there's a lot of upfront work when you start a new case. If they come in new, right, you got to do the filing, and maybe there's an RFO and discovery, or just the disclosures, all those things that take time. And then it's negotiation. I think does it start off pretty heavy billing, and then it kind of mellows out, and then if there's court, it's going to pick up again. Is that kind of what people would see?
Yeah, that's generally how it is. I mean, I think it starts out moderate because you have a lot of things to file and get information and all that. And then it kind of mellows out. And then if you have hearings, it goes up and down. But I found that generally, like, it depends on how litigious the case is. So you can kind of tell up front, depending on like how much assets there are, how, what the debts are, what the incomes are generally, and then the personalities too of your client and opposing counsel. You can kind of tell pretty soon how you think the fees are going to go. So, but either way, if they have an invoice 1 month that's half of what it usually is, they're never going to complain, right? It's just when it's above what you've quoted them. So that's why you have to be careful and not quote too low as an estimate.
Gotcha. Yeah. So I had a couple questions that I wanted to ask you, and I know we just got right into this with our conversation. So one of the questions I wanted, if we could back up and then we'll get back into what we're talking about. Why did you decide on family law in the first place?
It's a question I don't know how to answer. Every time I tell everybody I'm a family law attorney, that's always the first question is why? Because it seems so, I guess, awful to a lot of people to deal with. But for me, I find it, I think as you were saying, what we were kind of discussing in the beginning, is that I find it satisfying. I mean, because at the end of the day, I'm dealing with people at their worst, and I'm able to protect them and help them in some way at the end of it. So whether that's through settlement or through trial, there is some resolution that comes out of it. And I think I've definitely seen, not everyone comes out of divorce completely bitter. Not everyone comes out of divorce hating their attorney. It really depends on the relationship between the attorney and the client. And so I really try to foster that relationship with the client where they know that I'm looking out for their best interests. And if that's to save money, that's one thing. If that's to, protect their assets, that's another thing. But the strategy is always going to change depending on who you're working with. And so it's really important to foster that close relationship with your client. They're not just a number, they're not someone that you're just trying to put on your invoices each month. And that to me is the satisfying part, is not just getting the results for them, but if you have that relationship for them, they're going, it's going to be that much more rewarding because you really are rooting for them. It's not just in your job. They always say not to take your job home with you, but it's really hard for me not to do that. And I'm okay with it, if I find that it's worthwhile. And I think that it is, the more that those relationships are cultivated with clients.
Yeah, I think it's definitely something. I think it would be unnormal to be able to put all of what you deal with, especially in family law, behind you. If it was like business law or something that's non-emotional, not dealing with people like that, right? I mean, there's no way you can't. I'm sure you're going to bed some nights and you're like, oh gosh, I wish I could not be thinking about that right now, right?
Yeah, of course, all the time. But like I said, I think it depends on the outcome. Like if I'm thinking about something 24/7, a hearing coming up, and we win that motion, that's worth it to me. It's not even about the money, and then to see the client happy coming out of court and saying, he's going to go to Vegas this weekend. Like, that's amazing. I love that, and that's kind of why I do what I do. It's an emotional practice, but for some reason, it's almost like the client's emotions kind of regulate mine. Like if I was overly emotional and they didn't care about their case, I think that would be a problem. But because I see them and they're emotional and there's so many different ways that this can affect their life, I feel like it's justified.
Talking about, emotions, all that, can you just kind of go into the next question of emotions is common misconceptions people have about family law is, and do you have to have those conversations and kind of be more of that guiding light on how you see that process going?
Yeah, I mean, yes, that happens a lot. I think just as your job as an attorney is to make sure that you do clear up some misconceptions with clients, And then also with just the general public that asks you about what you do for a living, even though I don't think that you're required to. But that's, that's kind of the process, right? And it's a practice. So every day, I mean, every judge is different. Every client is different. Every case is different. The law is always changing. So the facts are always changing. So, but yeah, I think clearing up misconceptions are part of your job, part of what you do every day. And that's okay.
Are there one or two that are there any commonalities of misconceptions, or is it just across the board?
I think dealing with, in terms of client misconceptions, I think a big one, honestly, is with child custody cases. They just, a lot of people just can't grasp the fact that, you're probably 90% of the time not going to get your child all the time. You're going to have to split it with the other partner. And I think because it's such an emotional process, people really get wrapped up in these little things that are happening, and it's like, well, he was an hour late 10 times, so therefore I'm going to get primary custody. And it's just like, it's just not the case. And it's hard to manage that with somebody because I understand why they feel that way. It's like, look, he's being irresponsible. Maybe he shows that he doesn't even care about taking care of the kid. Well, it doesn't matter. He's the father. As long as the kid's under 18, the court's going to generally want both of you to see the kid unless there's something one of you is doing that's severely detrimental to them. So I think that's like the biggest misconception. It always revolves around child custody, probably because it's just the emotions are like tenfold because they're dealing with they're dealing with their kid, and then they're dealing with their kid with their ex who they now hate. So I think that's the biggest one. And then probably the second one is, of course, cost. I think a lot of people have a misconception that divorce can cost, a couple $1,000s and then it's over. It can, but if you're litigating, it most certainly won't. So like we were saying before, I think clearing those things up beforehand is always going to be more helpful to the client.
Are these things that kind of come up in an initial consultation, or is it in addition to that also management of emotions and so forth throughout the process? As I say that, I guess the answer is probably yes to that.
Yeah, yes to both. It'll come up in consultation. Sometimes it doesn't. And it's just kind of a process. When it comes up, it comes up. And I think nipping it in the bud right then and there is your best way to handle that.
Makes sense. The child custody issue, do you find that people, I think this is what you were saying, but I just want to ask you again, when it comes to the kids, do people seem to focus in, or they can tend to focus in on one subject, not necessarily the kids, maybe it's spouse support or, property division, whatever it might be, versus looking at more of a kind of a global settlement. How do you manage that with your clients to say, hey, yes, you're kind of not getting everything you want over here, but if you're getting a little bit more than you want over here?
Yeah, I think that comes up all the time. There's always going to be one issue that somebody is more emotional about than the others. Most of the time it's child custody. Sometimes it can be support. Sometimes it can be something really small, like certain items that they have at this ex-spouse's house. A lot of times it is the home itself because it's their marital home and nobody wants to leave it. So yeah, there usually is like one or two issues that they tend to focus on more. And I think the second part of your question was, how do you handle that, or how do you handle that with the client?
Yeah, we were just saying, no, that was it. Basically, that we were talking about the global settlement versus people focusing in on a specific
and then I think
issue.
you asked how do you
like redirect them?
Yeah. I think, that's always a process that has to happen all the time. I think a good redirector is letting them know that you prioritize this issue as much as they do and focusing on it as much as they are, because that is what's important to them. So you can't just ignore it. But I think also, yes, coming into picture everything else that's at issue, and maybe okay, let's redirect your attention for a couple weeks or a couple months on these other things that we need to get resolved. But I do think that once they feel that this issue is just as important to you as it is to them, and they see that you're taking action about it, then things naturally just kind of become more in perspective for them.
Gotcha. If we could move, since we're about litigation in court, I want to ask, if it's okay, some specific questions just for my knowledge base. And so when I'm talking to my clients on how things, like with us, they have to decide everything. And I can point them in the right direction as far as, sending them links written by attorneys that explain certain things. But obviously, the law can be very gray, a lot of gray as far as how things, there's, it's not very clear cut. It's not black and white, that's for sure. So I'll send them several links for the information written by attorneys so they can kind of digest that and read that and see how they want to play that out and maybe use that for their own negotiating versus, before they step off with attorneys to go and try and figure that out. So I want to, again, for my benefit, so I can help my clients in the future, but I want to talk about a couple specific things to see what you're seeing in court on things that we are trying to help our clients through. Because sometimes they'll say, well, according to this article, if you go to court, this is a kind of similar situation and this is what happens. You might want to consider that. With you had brought up the family home and not wanting to sell it, we are seeing, it seems like there's always one spouse a lot of times that wants to keep the family home, especially if there's minor children involved. They want to keep the family home. And many times both spouses are agreeing with that. And we're getting some interesting settlement agreements that we're putting together for them to include, even with young children, them maintaining the home together for 10, 12 years until the kids turn 18 for a variety of reasons. One, they want to wait till the kids turn 18. Two, they don't want to refinance at today's high rates because maybe then the 3%, and if they refi, it's at 7. We had one today where they just bought the home like a month ago, and now they're getting divorced. But now, so if they sell, there's going to be capital gains. So there's just there's a whole variety of reasons people are keeping the home. What are you seeing the issue I want to bring up is in a case where a spouse doesn't want to refinance the property because they don't want to get that interest rate, but the other spouse wants to get bought out. They don't want to wait years and have the market fluctuations and see what happens. Are you seeing that in court? And how is the judge handling, like, what are some of the things that judge weighs in making a decision on whether they should sell it? Because the judge ultimately can make the decision, order the house sold, right? Or go see if you can refinance it regardless of the rate and do the buyout. What are you seeing in court kind of related to that?
Yeah, I mean, generally the judge in the court doesn't like to make really intricate decisions like that without either like experts being involved. But generally speaking, if the parties can come to some sort of agreement, even to some of those issues, like for example, they can agree on the refinancing. That makes a big difference. So I think if they can, I mean, it's easier said than done, but if they can come to an agreement in some respect regarding the house, that's always going to look and be a lot easier for the court to deal with, even if it's not to every issue regarding the house. And then I think also a thing, something that a lot of couples can, or divorcing couples can, should utilize is other resources besides just attorneys. Talk to your real estate guy, talk to your finance guy. They're always going to give you kind of creative options that your attorney is not able to give you. And I think don't be afraid to just enlist people that you think will have your best interests at heart in that regard, especially like a financial consultant, things like that, because I've seen them come up with solutions for them that obviously, I can't come up with. I had a client who had an issue, same thing with the home, and she hired a real estate attorney to help her with coming up with different ideas. She had a financial guy that she was friends with, and so they worked together, and then they were giving me the advice and what they found and what they suggested, and then I was applying that, and then it ended up that they were able to settle that. So I think being able to, if you can't come to a settlement, if it's too complicated, then I think enlisting experts either to testify for you at trial, worst case scenario, or I think the better option too is just not be afraid in consulting other professionals, whether it be legal or financial, to help you come up with a solution that's a little different.
I find that interesting that, if I understood you correctly, that the judges don't necessarily make intricate decisions on certain things. At what point will they, once they have had to their satisfaction all the information they think they need to make that decision? And I would imagine that that doesn't happen at a single hearing. It would be get this information, have these experts write their report and submit their declarations, and then they'll take it under consideration for a future hearing. But at some point, if the parties don't agree, the judge will eventually have to make a decision, correct?
Yeah, that's right. And then at that point, that'll be at a trial. And then at that point, they'll then take into consideration all the other issues. So of course, the family law code and the courts are, at least in California, the general policy is to make sure that both parties are coming out with an equal division of pretty much everything. So if they can, whether maybe some person gets the house, well, then they'll get a buyout, or this person refinances, this person will get credit for it, or they pay the mortgage, they get credit for it, things like that. So at the end of the day, when there is something that's really intricate, detailed, and maybe the judge doesn't have the tools to decide what's best, they will, of course, consider everything that's involved, the whole marital estate, and try to divide it in a way that is generally equal.
So, and again, it's interesting that because the judges aren't just outright making decisions for people, and they kind of push it back on the attorneys and the parties to consider their options and making decisions, as far as with, say, now jumping over to, community property. You had brought, we talked about the house. You're talking about, we can talk about 401ks, pensions, and buyouts, and just like offsets, for one asset for another, one debt for another, et cetera. Is that happening with that as well? They're kind of pushing that back to the attorneys to go for further settlement, or to the parties to sit down again and discuss it, as opposed to the judge just outright saying, well, this is what I've decided, because is that kind of the judge's last resort? Like, okay, you guys have tried to do this 3 hearings later, I'm just going to make the decision.
Yeah. I mean, generally speaking, in family court, that's what you can expect, is like the judge really wants to see you come to them with something that they can work with. So, obviously, worst comes to worst, you have a trial and then they'll decide. But yeah, it's an interesting thing, because there's not a whole, the idea that you're playing with dividing things equally actually makes it kind of easier, because it's like, okay, well, this thing we cannot decide on, but, the judge will make a decision on that. And okay, you're losing, you can quantify it. Like, you can quantify how much time you're losing, with the child, for example, or you can quantify how much money you're losing with this asset being given to the other side. So then there is a way to ultimately equalize it at the end.
Right. Whether it be through equal division or some other offset from another asset or debt. It's so interesting. Before I got very, very, very strict about the type of clients I would take. Now, again, if you're not 100% in agreement, I'll turn you away. But before, we'd get, say 5 years ago, still like, 5 years into this, I'd have people say on the phone, yeah, we're not in agreement. Just, I want to get to court and see what the judge orders. So with this information, that's not quite how that works.
Yeah. I mean, of course, if you're not in agreement, then you have to go to a hearing to resolve it in some way. But I guess it depends on the issue, because the judge is ultimately going to order something at some point. And I think it really depends on who is bringing the best case, right, to the judge. So if some person's not bringing much, then they'll probably rule in the other person's favor. So it'll balance out in some way. But yeah, I mean, it depends what you're talking about, because there's so many different issues that you can necessarily disagree on. And then how you present your case to the judge, let's say both people are pro per, is really going to decide the issue. Because yeah, they're going to most of the time decide on it, or sometimes they can send it back and say, I want you to meet and confer about this, and continue the hearing. But ultimately, at that continued hearing, whoever is going to be presenting the case that's strongest, has the most, evidence to back it up, is in line with what the law says, that's who the judge is probably going to rule in favor of. So I think too, to talk about more about what you were saying before with pro per litigants. I know it's hard to say, oh, look at the law and try to follow the law, but really that's kind of what it is. I mean, the judge, it's a rare occasion when the judge is going to like come completely out of left field and make a ruling that you couldn't foresee. So if the law says, generally that there's going to have 50-50 custody, then there's probably going to be 50-50. If it's not 50-50, like joint legal, joint physical, then there's going to be some sort of offset with it. So if you go in knowing that, it'll help manage your expectations on what to expect at the hearing.
Can you explain that more? I may have misunderstood you. So you're saying if it's joint legal, joint physical, or like 50-50, there's an offset. What were you referring to?
Oh, I mean, if the judge doesn't order joint in both, joint legal, joint physical, then there's still going to be, let's say one parent has sole, there's still going to be visitation time for the other parent, right? So there's always going to, essentially, one person is not generally going to get everything, or even most of everything. There's always going to be a balance.
Gotcha. Yeah, when I was talking about this, about let the judge decide, it was usually specifically about like child support and maybe spousal support. Because what we do for our clients is we'll run, a district master calculation based on timeshare and incomes, and say, hey, this is not the rule. Use this as a guide. This is not necessarily what the court would order. You're better off, you guys are amicable, sit down at the kitchen table and look at your finances, see what you need to receive to make it, see what you can afford to pay, and see if you guys can find some middle ground. A lot of times people will come to us with already an agreement in mind as far as spouse support and child support. Some people have no idea. They'd like to see what a report looks like, a district master looks like, to see just as a launch off for the conversation, because they think, well, this is could it be what the judge orders? Sure, but they're not going right off of the calculation. And correct me if I'm wrong, I don't believe the courts are even using those calculations for long-term support, are they?
Yeah, usually not. That's just for temporary support, but it does give you somewhat of an idea.
It'll be so it's kind of somewhere in the ballpark, right?
Mm-hmm. Yeah.
Yeah, gotcha. So at least I'm feeling good. I'm on the right track as far as trying to help, because I don't do mediation. I honestly, I tried that 4 or 5 years ago, and I just didn't have the temperament for it, because people, we have a lot of mediators we refer to over the years, and even they say, yeah, we get beat up all the time. Like we had the last people we have here in Santa Clarita mediation firm, they retired, and they said, oh, we couldn't take anymore. The clients always beating us up. So I think that those 2 cases I mediated, I literally said, they say, you want to make a decision. I said, once I do that, you guys are done. You're going to think I'm not on your side, and you guys got to make the decision. But just to hear people bicker and go back and forth, I said, that's it. I'm going back to what I do best. I think it was 2 cases I did, and then I was done. So
I know, right? Sometimes it's easier just to, well, no, for you, because you like to just have it uncontested. But I mean, sometimes it's easier to just give into the fight.
Yeah. Because they'll say that when the people that do go to mediation, they'll come to us and say, what does mediation even do? We went in there and talked, and we'd say, hey, we want you to make a decision, and they won't make a decision for us. And I said, that's not their job to do that, to keep the conversation going and give you additional information to help you guys make those choices. I said, you can always go to court and go through all those motions to eventually get into court, but it's interesting to hear that it's getting pushed back on them to make the decisions in many instances on certain subjects.
I think in particular with child custody, I see that all the time with people coming into court and they want to change custody. And, especially if there's already a court order, it's just, they don't want to change it. It's, unless there's something that's, obviously change circumstances. If there's something that's like really pressing or clearly hurting the child, or clearly something a lot more beneficial. And they'll, judges will always make little orders here and there, interim orders and things like that. But I mean, actually changing the full schedule, it's difficult. They'll make concessions here and there, but I think particularly with co-parenting, they just want to see that you're co-parenting, because they don't want to have the court intervene in your personal life to that extent, and I think that that's for good reason, because otherwise, I mean, people still go back to court all the time to litigate it, no matter what the judge says. But yeah, I think a good strategy when you're dealing with divorce is that if you can't agree on everything, there are probably a lot of things that you can, concede here and there. They do the same for you. And, temperaments kind of also go down after that, because you see, okay, we're contentious because we're emotional, but there actually are a lot of things that we can agree to. And sometimes that does take a hearing or two to realize, sometimes it does take a bad ruling to have a party eventually say, you know what, I honestly don't care about that issue. I'm okay with it now. And that's unfortunate, but that is the case sometimes, because they kind of sometimes have to see that that's the reality of it, that you're just not going to get everything that you want. And I think that's why people get frustrated with mediators in particular.
That seems to be the theme of this discussion, is when folks go to court, you're not going to get everything you want. If you try and modify something, you may get one of the 10 things you asked for, but likely
usually
not.
That's the case. I don't think I've ever gone to court and got every single thing granted exactly. There's always one or two little issues that, will eventually either, it may not be denied full out, or, but there's always going to be a give and take. Yeah. Because it's so nuanced. I mean, the issues are always so nuanced, and the facts are they change all the time. So, it's to be expected.
We were earlier talking about managing client expectations, or maybe we weren't, but how, just in talking about you guys go to court, there's opposing counsel, you're fighting for your client's rights, opposing counsel is doing the same. It's going to land somewhere in the middle. How do you manage the expectations of your clients? Do you have conversations prior to the hearing and say, hey, look, this is what we're asking for. We may not get everything. We might get nothing. I mean, because you don't want to have a hearing, you come out and then your client's pissed off at you, right?
Mm-hmm. Yeah, I mean, I try to do that, before we even file a motion, because
that would make sense.
Yeah, I mean, that's really important. But obviously there are times when the client, because I'll always say, look, here are your options. This one has better luck at succeeding than this one, or whatever. Which one do you want to go with? And then if they still choose the one that's probably not going to be granted, I remind them of that again, still file it. And then I think now their expectations are generally managed. And then if you show up to the hearing and you prepare and you do everything you can to advocate the best you can, client expectations were managed properly. And so they're not going to get mad at you. They might, they may not be happy, obviously, but I think that's where it's really important to always be thinking ahead of how, what is the actual, what do you think is actually going to predicting what probably will happen in court. And, that's scary, because as an attorney, we're so risk averse and we're so scared of getting sued all the time. And so It's like, oh, we don't want to tell people this will happen or this won't happen. Right. But so it's really difficult for us, I think, to do that, but you really do have to do that. Obviously you don't have to use absolute language like we're going to win or we're going to lose, but I think that's where actually having the knowledge is going to help you, because if you're just kind of guessing, I don't know, it depends, we'll see what happens, that's not managing client expectations. You really have to look at the law, look at, what you've seen in the past, maybe what you know about this judge, and then lay it all out there for them. So it's pretty clear how you think it's going to go. And actually I try to track what my predictions are for different motions, and then what the outcome is depending on the judge and different things. And because that helps me to see like, okay, am I way off here? If I am, why? What did I get wrong? Am I not up to date on, I don't know, like not the law, because the law generally is the same, but it's like, what am I missing? And so I try to always keep track of that, because I think that's super important. And then it also helps your business, I think, as an attorney too. You don't want to just be the attorney that's like, oh yeah, I take you to court and we lose every single time. You know what I mean?
Right.
You want to be like family law. There's always such an emphasis on collaborating and trying to come to an agreement, trying to be equal. But there definitely are times where you win and you lose, and and that's obviously a lot more satisfying to win with your client versus losing. There are times where you can't help it, because that's just how the law is and that's how the circumstances are. But like I said, I think if you're really doing your best to lay it out there, manage client expectations with your client, and then also really trying hard to win anyway, that's the best you can do.
Makes sense. I want to ask you a question. I don't know if you are okay answering it. A lot of, we, as you know, we do the flat rate, flat fee pricing, because we know what we're getting into. Some are a little bit more difficult than others, but it's evened out by the ones that are the harder ones are evened out by the easier ones, is what I'm trying to say. But when people are shocked when they realize like what the average cost of going through divorce can be, and I know that can have a big range. Are you able to say with the average divorce, not under litigated, not over litigated, some court, some hearings, some, what would you ballpark a divorce case just on one party's side in your estimation?
I honestly couldn't ballpark it. I know you can look up statistics. Yeah, I mean, you could look up statistics because they exist about the average cost of divorce in California and in the United States, but it really depends. I think that if you are, but that's the thing. It's like, if it's litigious, well, what does that mean? Yeah. But I would say if it's litigious, meaning there's probably going to be a trial on one or more issues, you're looking up to hundreds of thousands of dollars, because it's also over the course of several years. If it's something that's like a short-term marriage and maybe there's not a whole lot of things that you're going to court for, and you do eventually settle, probably closer to like, tens of thousands range. But so that's like the general ballpark, but I can't say that going in, because you really don't know. I mean, like I said, you can ballpark kind of like, okay, I think that this case is probably going to be pretty like a lot of conflict, and this one may not be. But you sometimes get surprised, sometimes you get surprised with how they eventually kind of are able to come together, and you're like, oh wow, this is a lot easier than I thought it would be. Sometimes they get, it's so dependent. But I think if people were worried about that, I would say, if you're hiring a lawyer for your divorce and they're working on an hourly basis, expect to pay a lot of money. That's what I would say. Don't even think about like, well, can I limit it? You're not going to minimize it. Every attorney that you go for that's on an hourly basis, you're going to spend more money than you want, no matter what it is. Whether it's $10,000, $100,000, you're going to always spend more money than you want. So if you want a divorce that's cheap or free, then I would suggest not hiring an attorney and maybe doing what you do. If you can settle with your partner. If you can't, you can always represent yourself. So, there are options, but it's expensive to hire an attorney.
No, for sure. I think the last time I did a Google search on that, it said $17,500 per person. So that would probably be.
But see, is that contested? Is that uncontested?
Yeah, exactly.
Exactly.
Yeah. And talking about how I want to make a comment. I think the answer that you can give on every answer to what does the law say on this is it depends, right? Because it's every same. I mean, you have
Oh no, you cut out there.
Oh, sorry. I was just saying there's no two cases that are ever exactly the same.
Yeah, it's true.
Yeah.
But I think, I mean, it's true, but it's also like, if you like, there is kind of a general formula, especially with things that involve like child support, spousal support.
Yeah.
If we know the timeshare, if we know the party's incomes, we can generally guess what it might be, things like that. But yeah, it's it's so fact specific. It's so
Sure.
case specific.
How can, and I know it happens, but what are the issues being litigated that can cause a divorce to take years?
Oof, anything.
Like what, name one that, like, is there one overarching thing that people dispute that just, is it that because there's so much discovery that's taking all this time to gather? Is it just because hearings are 4 and 5 months apart? Is it, what could you,
I would say both. I think a big one, I don't know if it's the most, the one factor, but a big one is spousal support and long-term spousal support. And especially if one party is the big income earner and they have a lot of different sources that they're getting income from, that can take a long time because then you have to hire experts. Anytime you have to hire an expert, it's going to take even more, several more months. They analyze RSU income, analyze maybe even bonus income, and et cetera, et cetera. It's just, it can really be endless depending on, the complexity, but also if the other party, it depends on how the other party wants to view it, because one person's income can be as complex as ever, but if the other party's like, you know what, I don't care, we're just going to stipulate, or okay, we're just going to go with their IED, whatever that says, then it's, it's okay. But it really depends. And I think that also turns on their attorneys, because there are a lot of times where I've had clients where the other side is just going after them constantly. And then it's like, no, that's not your income. No, I don't believe you. Okay, motion to compel. And it's just this constant barrage. And I'll have a client be like, that's really my income. I'm not lying. This is what I have, and a lot of attorneys are just like, yeah, that's probably what it is. And they'll say to me, the client will say, well, I don't think it's her doing it. I don't think it's my ex actually wanting this. I feel like this is her attorney, because she wasn't like this when we started, and so it could be, it could be that they get wrapped up in what because if you're an attorney, like, if you're a divorce attorney, you want to litigate, you want to make sure that you're getting the best result for your client. So it's understandable that if your client says, hey, I think he's hiding income, or he's hiding this document or that, maybe you do want to, do everything you can to discover that and compel that from them.
Right.
But yeah, I think it's a lot of different factors. It could be the attorney, could be the other party who's really they're just gung ho and they want to do it. But yeah, to answer your question, honestly, there's so many issues in divorce that could go to trial, but I do think that spousal support is a big contentious one. There's always going to be issues around that. Yeah.
Interesting. Is there anything else you wanted to chat about? We've talked about quite a bit.
No, I think we covered a lot.
We did. Yeah, we should do this again. Yeah, this was great. Kimberly Keen, family law attorney, San Diego. I was glad to send you a referral the other day. I don't know if they called, but I'm glad. Yeah, I'm glad to have an outlet. Like I told you when we first talked, I'm a good referrer because I'm so specific on. Fortunately, we have a lot of inbound calls, so I can, if we get 10 calls, I'll take 2 of them. The rest need attorneys, or I'll give them to other LDAs, just because it's just on the stickier side of things, and I'd rather do the things that are simpler and that I enjoy, and then do more marketing. As you know, I sell myself on the internet. So I'd rather spend my time doing that than getting into the dirt with some of the people that are calling. But yeah, I'll be happy to keep referring to you. And it was great talking to you. Hang out.